those individuals who would try to cross our border illegally. Third, DHS must build 700 miles of fencing. That's double the amount required in the underlying bill, which calls for 350 miles of fencing. 700 miles of fencing, that compares to about 42 miles of fencing we have in place right now. Fourth, the Secretary of Homeland Security must verify that the mandatory E-Verify system has been implemented to enforce workplace laws so that illegal immigrants are not employed. And fifth, the electronic entry-exit identification system must be in place at all international airports and seaports in the United States where U.S. Customs and Border Protection officers are currently deployed. So these are the requirements. These are the requirements, and they must be met before lawful permanent residency is allowed. No green cards other than for dreamers and blue card ag workers until these requirements are met. Once again, simply put, we must secure the border first. That's what Americans demand, and that's what we must do to get comprehensive immigration reform right. That's what this legislation does, and it does it with objective and verifiable methods. We ask our colleagues on both sides of the aisle to join with us and to pass this legislation. Thank you, Madam President, and at this point I would like to turn to my distinguished colleague from Tennessee, and again I want to thank him for his tremendous work, which is ongoing, but I just can't say how much I appreciate his good efforts and his good faith on a bipartisan basis. I turn for his comments as well as then to enter into a colloquy with our colleagues who have worked so hard and played a real leadership role with this legislation. Senator Corker.
I want to thank the Senator from North Dakota for his outstanding leadership. You would expect that from someone who served in such a distinguished way as governor of his state. He's used to leading. He's done an outstanding job on this issue. I want to thank him for being a great partner. I know we still have some work to do. I mean, the fact is we still have to introduce this amendment, and work is underway right now. But I want to thank him, his staff, and all around him for the way that he has dug into this issue, solved the problems that I think Americans are looking for relative to security issues, and working with us in the way that you have. Thank you very much. And I want to thank the Gang of Eight for the work that they have done over the last multiple months to bring us to the place that we are, where we have an opportunity to do something that America needs, and that is to solve the immigration issue that we have, and to also ensure that in doing so, we've absolutely secured the border. One of my colleagues called this amendment, and again, it's being vetted right now. We hope to introduce it a little bit later today. There is a broad agreement about what the content of it is, and it is again being vetted and will be introduced later today. Some people have described this as a border surge. And the fact is that we are investing resources in securing our border that have never been invested before, a doubling, again, of the Border Patrol, $3.2 billion worth of a technology that we took from the Chief of the Border Patrol, the technology that he needs to have 100% awareness and to secure our border. Dealing with the exit program, dealing with E-Verify, so that all of these things are in place. I want to thank Senator Cornyn from Texas, who began the process of focusing on border security. I realize that his amendment earlier failed, but I think what he helped us do is build momentum towards an amendment that I consider to be far stronger and even better. But his efforts at looking at a border security measure, I think, helped us in this regard. So I want to say I'm not the kind of person who speaks for a long time. I think people understand that. I think the Senator from North Dakota has done an outstanding job of laying out the many elements of this amendment that hopefully will be voted on in the very near future. But I do think the American people have asked us, if we pass an immigration bill off the Senate floor, to do everything that we can to ensure that we have secured the border. That's what people in Tennessee have asked for. That's what people in North Dakota have asked for. That's what people in Arizona have asked for. And, Madam President, I think that's what this amendment does. I think this amendment has the ability, if passed, to bring a bipartisan effort behind immigration reform that would then sit in the bill of the House. Look, I do wish that this amendment had some other measures relative to interior security. And I think that the House can improve this. I think a conference can improve this. And I hope that we have the opportunity down the road to see that occur. But I want to thank all involved in crafting an amendment that I think tries to deal with the sensibilities on both sides and at the same time secure our border in such a way that we can put this issue mostly behind us and we can have an immigration system in our country that meets the needs of a growing economy, the biggest economy in the world, that focuses on making our country stronger, not weaker, and hopefully we'll put this debate behind us. And so, Madam President, I yield the floor. Yes, sir.
Yield for a question.
Yes, sir.
First of all, could I say all of us who have had the honor of working with you and the Senator from North Dakota are greatly appreciative of the work that you've done. If there is going to be a broad bipartisan support for the final product, it will be because of what you and the Senator from North Dakota have done, and I'm very, very grateful for that. And I think that it's important, wouldn't you agree, that people understand that this is a very tough bill, and it required a lot of cooperation from our friends on the other side of the aisle to go along and agree with this. I think that they've shown a great deal of compromise in order to reach this point and agree with us on this legislation, which clearly we need bipartisan support for. But I'd like to ask the Senator again for a couple of specifics, because I think it's important we understand how tough this legislation is. We know, isn't it true that already we know that E-Verify must be used by every employer in the country before anyone under this plan could be eligible for a green card? Isn't that true? It's already there.
That is correct.
And the electronic entry-exit system at all international air and seaports has to be up and operational before anyone is eligible for a green card. That's true.
That is correct.
Now, thanks to you and the Senator from North Dakota, isn't it true that that additional technology must be deployed and operational in the field? And that includes the new Vader radar systems, integrated fixed towers, unmanned aerial system, fixed cameras, mobile surveillance system, ground sensors, to the point where, isn't it true that the head of the Border Patrol has assured us that if these technologies are in place and operational, that we can have 100% situational awareness and 90% effective control of the border? I would ask my colleague.
That is correct. That is correct.
So, in order to finally put the final piece of this puzzle together, isn't it true that you and the Senator from North Dakota have called for 350 miles of additional border fencing in addition to the 350 miles that's already there, and 20,000 new full-time Border Patrol agents are hired and deployed before someone is eligible for a green card? Is that a fact?
That is correct. That is correct. I don't know of anybody that has proposed a tougher measure, when you look at it all combined, than the measure that hopefully will be on the floor in the very near future.
I wonder if the Senator from North Dakota would like to respond to that.
Well, I appreciate the esteemed Senator from Arizona again emphasizing these points. That's what this is all about. This is about securing the border. All of the things you just identified are in the bill. They're requirements. The plan itself, this $3.2 billion comprehensive southern border strategic plan, is detailed border sector by border sector. And again, this puts everybody in the same place, saying we're going to secure the border first, because there's no green cards until we secure the border.
Isn't that true? I'd say to my two colleagues, and Madam President, I ask unanimous consent to engage in colloquy with both the Senator from Tennessee and the Senator from North Dakota.
Without objection.
Isn't it true, I say to my friends, that on our side of the aisle there is understandable skepticism and well-founded skepticism on the part of my friend from Texas, because we've seen this movie before, In 1986, we gave amnesty to 3 million people, and we said we would secure the borders. Then in 2006, we passed border security appropriations, and there was going to be plenty of money, and it was never funded. So for those of us in the Southwest particularly, but people all over America, isn't it true that there's understandable skepticism that we would not pass legislation which is binding? And isn't it true that you can't make this, as far as Border Patrol and as far as miles of fencing, any more binding than it is in your amendment?
Absolutely. I would like to add that it's not just all these things that we're putting on the border and that we are requiring that these things are in place and certified and operating before you go to green card status, but also it's about eliminating the incentive to try to get across the border. When we put E-Verify in place and we have a proper guest worker program, you take away the incentive to try to get across the border. So we secure the border, but we also take away the incentive to come across, because you can come across legally through the guest worker program, and if you come across illegally, we're going to find you and you can't get a job. So it's both. That's what we mean when we talk about comprehensive border security and a comprehensive approach.
I'd ask my colleagues one more question. With all due respect to every member of this body, when you look at this legislation and you look at these triggers and you look at the technology that's going to be required, which, if operational, the head of the Border Patrol has said will give 100% awareness and 90% effective control, plus this increasing in fencing, plus Border Patrol agents, and the already existing in legislation to E-Verify. And I think the senator from North Dakota is very correct. You remove the incentive for people, if they know that they can't get a job in this country unless they have the proper documents, then people will stop coming illegally. And it also addresses the issue of the 40% who are here who never crossed our border illegally but came on a visa and overstayed it. I just would ask for maybe a subjective opinion. Is it possible that you could ever argue against this legislation now by saying that it does not give us a...
Mr. President, I ask unanimous consent that the time for debate only be extended to 8:30, and I be recognized at that time.
Without objection.
And we would have the time equally divided between the majority and minority during the next hour.
Without objection.
I would also say this, Mr. President. The amendment that we've been waiting for, I think, is done. I think we got the last sign-off just a few minutes ago. So there.
Mr. President, could I inquire as to what the UC just got agreed to?
Extend the time for debate only until 8:30. Time's equally divided.
Mr. President.
Let's do it. Yes, say.
The senator from Vermont.
President, I appreciate the senator from Nevada getting this unanimous consent agreement. I'm glad it was agreed to. And I commend the Majority Leader for his work he's doing on this. It is a slow process. It'd be an awful lot slower if it wasn't for the very accomplished hand of our Majority Leader. I yield the floor, and I suggest.
Mr. President,
Majority Leader.
I appreciate the distinguished chairman of the committee for saying some nice things about me, but my involvement in this is minimal compared to many other people.
Ask consent that the quorum calls be equally divided.
Mr. President, if we have someone suggests the absence of quorum, in the next few minutes I ask the time be equally divided.
Without objection.
Any other questions anyone has?
Senator from Alabama.
I appreciate the Majority Leader's, but he speaks softly and I don't hear it as well as I should, so I'm not sure what we agreed to or was he propounded.
Have you heard now that we've extended the time for debate only, time equally divided between majority and minority, until 8:30 tonight?
Senator from Alabama.
Here.
Who yields time? The clerk will call the roll.
They call the time be equally divided.
We're in a quorum, without objection. Clerk will call the roll.
Mr. Alexander.
Is that this is a promise of future performance, and there is no contingency in the same sense that there was a trigger that prohibited the transition from probationary status to legal permanent residency. Could the Senator please
Yeah, Mr. President, if I may
clarify
respond to that. I appreciate very much the question from the Senator from the great state of Texas, and I thank him for the work he did and the work we did together, and the fact that we absolutely tried here to build on concepts that you put forward. So it's not the same, but we tried to build on those concepts. In terms of the actual border security plan, the comprehensive southern border security strategy, the $3.2 billion plan that includes technology, helicopters, planes, all these different things that I detailed, that is exactly what you were talking about in your legislation. So physically, we do deploy all the things that you'd laid out in your legislation, and then we add to it 20,000 agents and an additional 350 miles of fence on top of the 350 miles of fence called for in the underlying bill. So we put all of the physical resources out there, and then we add all the fencing and all the manpower to make sure we accomplish exactly what you were laying out. And in terms of the trigger, all those things are triggers before going to a green card. So it's different in that the discussion was, how do we set up verifiable metrics? And that's what we're doing by clearly delineating all these things we're putting in, okay? And then we actually add to what you had in the legislation.
Would the Senator yield one last question?
I don't know who has the floor.
Yes, sir, one last question.
I would.
Because I know there are others who want to talk, and it's not my intention to interfere with their colloquy here. But the 20,000 additional Border Patrol, here's an area where the movement has been pretty dramatic, Mr. President, because we started with
Senator, a quorum call.
I would ask that consent to quorum call be dispensed.
Without objection.
Mr. President, here we are with an intent to have an amendment that's supposed to solve all the problems of this legislation, and we had it announced earlier this morning, and we hadn't seen it yet. And so we're now here. Earlier today, we thought we had an agreement to have as many as a half a dozen votes tonight. So we had some today. We're going to have some more tonight. We've only had 9 votes on this legislation as of today. This is really odd. And so we haven't seen this bill. We don't know what's in it. Everything has been stopped, waiting on some agreement, as Senator Schumer said, among the allies. He said they're showing the bill to allies. Apparently hadn't shown it to Senator Lee, hadn't shown it to me. So the allies of the Gang of 8 are going through the bill. I don't know if they're going to have Nebraska kickbacks in it or Cornhusker kickbacks or whatever else they're going to put in it to get somebody's vote on it. I hope that's not where we're going. But what I'm concerned about, having been around here a few years now, is that we'll have a vote on cloture on this amendment. They're going to file the amendment, immediately file cloture apparently, and then have that vote early next week, and then have a couple of more votes. And the next thing you know, we're at final passage and no amendments have been allowed of significance to occur. I have a number of amendments. The House has done a really good job in working on the interior enforcement weaknesses of our current law. They've put together some good language. I've taken a lot of it and put it into an amendment. I'd like to have a vote on that. and we ought to talk about it, because there's some feeling around here that the only thing that matters is the border. But that's not so. 40% of the illegal entries into America today come by visa overstays, and that's not dealt with at all or any significant way that I'm aware of in this new amendment, which we haven't seen. So I'm worried about this whole process. American people deserve an open process. It was promised that. We had, how many amendments we had in committee, Senator Lee? Lots of them. But we only had 9 now, and we lost a group that we were going to have today, and we can't tell from our discussions with Senator Reid and others if there'll be any more amendments next week. Because I guess the powers that be, the masters of the universe, have all gotten together and they've decided this. They've decided that everything is fixed by Hoeven Corker. And we'll just pass that amendment and nobody else will be heard. But that amendment, from what I read in the papers about it, in general, doesn't fix anything like the loopholes and weaknesses of the legislation. Senator Lee, I appreciate your eloquence on this issue, but I did want to share that I feel like that something is going awry in the open, debatable process that we thought we were going to have for a day or two that seemed to have jumped off the tracks completely.
It does indeed. And, you know, I was disappointed by the fact that in Judiciary Committee, on which you and I both serve, we had a lot of amendments. I don't remember exactly how many votes we had in committee, but it was in the dozens, if not scores. And we had extensive discussion. Now, not all the votes turned out the way that you and I wanted them to. But the important thing is we had a lot of discussion. We had on-the-record debate. We had amendments proposed and discussed and debated. And that's not how it's happened this time. In my understanding, I wasn't here, unlike my friend from Alabama, in 2007, the last time we had a comparable discussion of a bill like this one. But my understanding is that there were 50-something, perhaps 53 amendments that were debated, discussed, and received votes in 2007. And my understanding this time around is that we've had 9 votes and maybe 2 or 3 that were taken by voice vote. Now, that's not enough. It's certainly not enough when you're talking about a bill that's more than 1,000 pages long, a bill that is going to affect many millions of Americans, and it's going to do so for many generations to come. The American people deserve more than this. They deserve more than just debate and discussion, you know, roll call votes that can be measured in the single digits. They call this the greatest deliberative legislative body in the world, and yet we make a mockery of that description when we do things like this, when we allow a 1,000-page bill to be rammed through in a matter of days with only a small handful of amendments debated, discussed, and amended. So through the chair, I'd like to ask my friend and my distinguished colleague from Alabama whether he has seen anything like this in his career, whether this is something that I should anticipate moving forward as I look forward to my years in the Senate. Is this something that I should expect on a regular basis with legislation like this, of this complexity, of this level of importance? Is this something that is just par for the course?
I'm afraid it's becoming par for the course. I remember we had a bill, bankruptcy bill, a fourth of this in size. I think it was on the floor 3 weeks, and we had maybe nearly 100 amendments. And a lot of people, everybody had their chance to speak, and we ended up passing the bill with well over 80 votes. But the point is that in this new mood in the Senate, we have a situation in which the majority leader too often fills the tree and controls even the amendments that are brought up. And in fact, as you know, isn't it, do you think it odd as a new member to the Senate and a student of law and Washington governmental processes, isn't it odd that a senator can't come to the floor and offer an amendment without seeking permission of the majority leader, and he says, no, I won't take your amendment, I'll only take this amendment? Does that strike you as contrary to what your understanding of as to how the Senate should operate historically?
Yes, in fact, I find it appalling. I find it repugnant to the system of government under which we're supposed to be operating. I find it even repugnant to Article 6 of the Constitution, which makes clear that there's one kind of constitutional amendment that is never appropriate. You can't amend the Constitution to deny any state its equal representation in the Senate. And if at any moment we end up with a situation in which we have second-class senators, senators that may submit and propose for debate and discussion and a vote an amendment, if we have to go to the majority leader and say, Mother, may I, then perhaps we've lost something. Perhaps we've lost the environment in which each of the states were supposed to receive equal representation. It also seems to me to take on a certain character, a certain banana republic quality, that we're asked to vote on legislation in many circumstances just hours or even minutes after we've received it. We take on a certain rubber stamp quality when we do that. I remember a few months ago, in connection with the fiscal cliff debate, as we approached the fiscal cliff on New Year's Eve, we were told by our respective leaders, just wait, something's coming. Go back to your offices, watch your televisions, play with your toys, do whatever it is that you do, but, you know, be good senators, run along and stay out of trouble. We're taking care of this. We'll send you legislation as soon as we're ready. Well, at 1:36 a.m., we received an email, and attached to that email was a 153-page document. That was the bill that we would be voting on. That bill was one that we would be called to vote on exactly 6 minutes later at 1:42 a.m. So to my utter astonishment and dismay, senators flocked into this room and with very, very little objection ended up passing that legislation overwhelmingly. This is just one of many examples I can point to in the 2.5 years since I've been here, when members have been asked to vote and did in fact vote enthusiastically, willingly, and hardly without a whimper of objection to legislation that they had never seen, to legislation that they were familiar with only to the extent that it had been summarized for them. Now, that brings us back to this legislation here. We've had this in front of us in one form or another for the last couple of months. But for a long time before we even had it, what we had was a summary of this. We had a series of bullet points. Those bullet points were very favorable, and for a long time the bullet points were all we had. The bullet points, I exaggerate slightly to prove a point, but they read something like this. Is this bill outstanding? Yes. Will this bill solve all of our immigration problems? Absolutely. Is there anything wrong with this bill? Heavens, no. That's how the bullet points read, and it was on that basis that groups around the country and some members even of our own body decided that they would vote for Senate Bill 744 even before Senate Bill 744 even existed. We had groups across the country, some even in my home state, that came out strongly in favor of the yet-to-be-released Gang of Eight bill, saying we're going to vote for it, and we're going to support it. And anyone who doesn't vote for it in the United States Senate is a backward fool. Well, they hadn't read it. They couldn't have read it because the bill didn't yet exist. Now, in some respects, what happened with this is very similar to what we're now facing with the yet-to-be-released Corker Amendment. I haven't seen it, but I'll tell you what I have seen. I've seen a set of very brief bullet points about the Corker Amendment. And the bullet points read something like this. Is this amendment outstanding? Yes. Will this amendment solve our border security problems? Absolutely. Is there any problem presented by this amendment? Absolutely not. So I say to my friend from Alabama, if this is what I can expect in my career in the United States Senate, I am a little bit troubled. But I would ask my friend from Alabama if there's anything we can do about this, if there's any way we can right this ship, if there's any way we can turn this around, this disturbing trend, separate and apart from the policies underlying this bill. Is there anything we can do to make this a real legislative body and not a rubber stamp? The kind of legislative body that actually does debate and discuss things. Because you don't really have a true deliberative legislative body unless you have enough time to debate things before we vote on them, to where the members can actually read them before they come up.
Yes, we can do that if we just follow the traditional rules of the Senate. And you're exactly right. Here we are being told that this legislation, this 1,000 pages, is all decided because somebody has got a bill, an amendment somewhere that nobody's seen, at least nobody that has any skepticism about it has seen, and that's going to solve all the problems. It's just rather remarkable. And on the fundamental question you raised about the Senate, I do believe, Senator Lee, that we need to begin to appeal across party lines and think more clearly about what's happening here. I talked with one of the great historians of the Senate, somebody I've known, and he's been here, worked on the floor, and he's written a book about it. And he said he hated to say it, but it's kind of getting like the old Russian Soviet Duma, where a group of people met in secret and put out the word, and then they all went and voted 990 to 10 for whatever it was the little group decided. And I'm worried that that has too much relevance to what's been happening here. I really do. A United States Senator, as you said, is equal to any other senator. The majority leader has power of first recognition, but it was never intended that the majority leader should say, you can't get your amendment, Senator from Alabama, only the one from Maine can get their amendment, and actually be able to execute that. It's just rather stunning, and that was not the way it was when I came. And this filling the tree process started maybe not long after I came, and both parties have used it, but it's now gone to an extent to which we've never seen before and adversely impacts the whole Senate. So I think you're so right about that. I just saw Senator Portman from Ohio. He has worked extremely hard on a very significant amendment and dealing with E-Verify in the workplace, and he's not sure he's going to get a vote on it. He thought he was going to get a vote on this. And then it's very frustrating for him that that won't be the case. And what is this? We're not going to be in session tomorrow, apparently. Nobody gets their amendments. Maybe virtually no more amendments get brought up of significance. So I am concerned about it, and I have a couple of key amendments. No, Senator Cruz has an amendment or two. You may have amendments. And amendments are valuable in that they point out weaknesses in legislation and they provide a fix for that weakness. And I think why would we want to deny people the right to make a piece of legislation better?
You know, one of the distinguishing characteristics of a democracy is that you have choices, you have options. I'm not intimately familiar with the inner workings of the Soviet government, but I have it on good authority that they had elections in the Soviet Union. But the big difference was the government decided who was on the ballot, and they decided that very, very carefully. Only those candidates that had been very carefully screened by the Communist Party officials could appear on the ballot. So the people had choices. It's just that the choices were really, really limited. They were limited so as to guarantee a certain foreordained outcome. Now, if you'll forgive the analogy here, what we have here makes sense, and it makes sense that all of the 50 states are represented, but only if, in fact, we are presented with actual legitimate choices, with actual legitimate options. One of the reasons why we've seen legislation pushed through at the very last minute and our colleagues in this body vote for that legislation overwhelmingly, is that they're told at the moment you have no other option. You've got a binary choice here. You can vote yes or you can vote no, but you don't really have the option of making any changes to this. And so a lot of times people vote for something, even if it's a bill that they otherwise didn't like, or if it had a lot of problems with it, they'll vote for it because they conclude that on balance voting yes is voting better than voting no. The problem is we are supposed to have more options than that, and in this body we're supposed to have the opportunity to propose amendments, and in theory to have unlimited debate and discussion. And unlimited debate and discussion necessarily really entails more or less unlimited opportunities to amend, to make it better. That's what real compromise is. Real compromise involves allowing all the stakeholders to come together and explain what's important to each member of the group, to each stakeholder. We don't have that here. We're supposed to have that in the United States Senate. Historically, it has existed. I know that not from my service here, but I know it from reading books and from talking to colleagues who have been here a little bit longer than I have. But it's time we restore that. It's time we restore what once existed but has since been lost, so that our democratic system of government actually functions as it was designed.
You led a press conference this afternoon with a group of Tea Party patriots. Jenny Beth Martin and a number of other people were there, and they came to Washington and had a number of people who had immigrated to America. And they spoke from their hearts about law and rules and proper procedure. Maybe you could share with our colleagues and those that might be listening the gist of that. But I thought it was a very moving thing to have people who came to America, some from countries where they'd been persecuted, and were so proud of the rule of law and really felt deeply that we need to be careful about what we do in the Senate to preserve the rule of law here. Thank you for leading that press conference today and letting those individuals, those Americans, speak their minds. And just in general, I would say that that whole Tea Party movement, which is many have tried to demean, came right from the heart of America. It represented a deep concern that people in Washington were out of touch, weren't connected with the real world, were not following the constitutional processes, meeting in secret with special interest and trying to win elections and not serve the people in an effective way. And I thought it was good to have them speak out today as they did in opposition to this monstrosity.
That's exactly right. The movement that you describe is a spontaneous grassroots movement that started in 2009 in response to an observation that swept across the country that the federal government has become too big and too expensive, in part because it's doing too many things it was never designed to do, in part because it's lost sight of the fact that it was always created at the outset to be a limited purpose government, one in charge of just a few basic things: national defense, establishing a uniform system of weights and measures, declaring war, otherwise providing for our national defense, protecting trademarks, copyrights, and patents, granting letters of marque and reprisal, which are fascinating instruments. It's basically a hall pass issued by Congress in the name of the United States that entitles the bearer to engage in state-sponsored acts of piracy on the high seas. So, you know, regardless of how long I might serve in the United States Senate, I do want to get a letter of marque and reprisal someday. I'm going to be a pirate. I hope my friend from Alabama and my friend from Colorado will join me. Among those other powers was the power to establish uniform laws governing naturalization, what today we would perhaps more broadly call immigration. That's one of our jobs. So it was appropriate that at this gathering today, where we were joined by a lot of supporters of this grassroots movement, we had some immigrants to this country, people who came here legally, people who sacrificed much, put a lot at risk in order to come to this country. And they explained that one of the things that attracted them to this country, one of the unifying reasons why all of them came to the United States, despite the sacrifices they had to make to get here and the risks that they undertook in coming here was the fact that they love the rule of law. They see the difference, as all of us do anytime we travel to a country where the rule of law is absent, that the rule of law makes all the difference. You can tell almost immediately after you step off the plane whether or not you're in a country where the rule of law is respected, where it's honored. There are relatively few countries in the world where it is. Fortunately, this is one of them. It's our job to make sure that it continues to be that way. Many of these immigrants commented on the fact that they find it distressing that while they expended the time and effort and resources to make sure that they immigrated legally, they're disturbed about the fact that under this legislation, well-intentioned as it may have been, under this legislation, 11 million people who came here illegally for whatever reason will eventually find themselves in a position of not only being able to stay here, not only be able to keep their current jobs, maintain their current circle of friends, they'll actually become citizens. This reminds me of a letter that I received not too long ago from a school teacher in Utah, a school teacher who explained that she had come here on a visa that will expire, I think, in 2017. She explained to me that she has every expectation that she will be unable to renew and extend that visa. So she said, I expect effectively to be deported in 2017 because I don't intend to break the law of the country whose laws I promised to uphold if they would grant me this visa. And she said, it's very distressing to me that meanwhile people who broke your laws, people who didn't respect the rule of law as I did, people who didn't expend a lot of time and money and resources and place a lot of risk in applying for and obtaining the necessary visa to come here, a lot of those people who broke all of those same laws will get to stay here, they will get to become citizens. And that's not fair.
And I thought that that group reflected those concerns very well, and I think the whole movement, the grassroots movement, did. And as I recall, Senator Lee, and you were involved in that election in many ways, it was a ramming through of the massive health care bill that nobody had read, and we were told, well, you got to pass it to find out what's in it. That generated that whole movement. And isn't this in many ways similar? And does it feel the same to you that we're moving rapidly through a bill of massive consequences, over 1,000 pages, and there's a lack of understanding fully of what's in it?
There certainly are some similarities. I will point out at the outset there are some differences. One of them being we have fortunately actually had the text of this for a little bit longer than I think Congress had the text of the Affordable Care Act when it passed it. We have had some opportunity to amend it in committee, and that's been nice. But yeah, there are a lot of similarities. Both bills are very lengthy. Both bills involve excessive, remarkably excessive delegation of authority to decision makers in another branch of government, within the executive branch. There are, by one count, something like 490 instances of delegated discretionary decision-making authority. You know, this is a problem because for centuries, great thinkers, including our founding fathers, but really going back even before them, have warned that the legislative power involves the power to make law and not the power to make lawmakers. To a very significant degree, the lawmaking power is not subject to delegation. It should not be delegated to someone else. Now, obviously, we have to delegate the branch. It's the executive branch's job to implement, to enforce, to apply the laws that we pass. But on some level, there is a difference that we can tell between giving someone the task of implementing and enforcing a law and giving someone else the task of coming up with policy. Either policy as embodied in the Code of Federal Regulations or policy as embodied in the exercise of pure discretion that will evolve and over time become its own form of law. And so this law, much like the Affordable Care Act, involves hundreds and hundreds of instances of delegated policy-making authority. One of the problems with that is that when you delegate policy-making authority to the executive branch, to the executive branch regulatory state, so to speak, you give it to people who, however well-intentioned, however well-educated, however wise, are not themselves elected by the people. They themselves don't stand accountable to the people at regular intervals. And they themselves can act in much the same way as despots might have centuries ago. Now, sure, their actions can be subject to challenge in court under the Administrative Procedures Act. But you challenge them in court under a standard that is very deferential and not to the challenger, to the government. One thing that is certain, you can't just go to them and say, look, if you don't change this law, I'm not going to vote for you again. They'll laugh at you if you tell them that, because they don't work for you. They don't ever have to stand for election. So that's one of the problems that I have with it, and one of the problems that it shares in common with Obamacare is this excessive delegation of authority. Now, it also shares in common with Obamacare the fact that it's really long. It's not quite as long as Obamacare, but it's still really long. Very often we find that really long bills go hand in hand with bills that have an excessive delegation of power to the executive branch of government, and that's what we have here. You know, I find it significant that James Madison warned us in Federalist number 62. It will be of little benefit to the American people that their laws may be written by men and women of their own choosing if those laws are so voluminous and complex that they can't reasonably be read and understood by those governed by the same laws. Madison was right to point that out. It's true. I mean, it's difficult to pick up a law like that, or twice its size in the case of Obamacare. It's difficult for the American people to just pick that up and read through it and say, yeah, I get it. I understand what my obligations are. I understand what the obligations of government officials are. I can understand it. It's 10 times worse than that when this is just the tip of the iceberg. When this will be a tiny fraction of the paperwork that will be entailed in the laws that actually implement laws like this one and laws like Obamacare. And so, to put it in Madison's words, it's bad enough when the laws are so voluminous and complex they can't reasonably be read and understood by those governed by them. It's that much worse when most of the actual law isn't even made by people chosen by the voters.
Well, I thank the Senator for sharing those insights, and it's important because we are getting to a situation where we're delegating to unelected bureaucrats extraordinary powers, and what we've seen with regard to the current administration and their enforcement of the law is one of the most dramatic, willful, deliberate failures to enforce the law I've ever seen. It has resulted in a most amazing circumstance. The ICE agents, the Immigration Customs Enforcement agents, who are out there trying to enforce the law every day, took an oath to enforce the law, have been so directed by their unelected supervisors to not enforce the law that they have reached the point where they filed a lawsuit in federal court against their supervisors. They sued Secretary Napolitano, and they said she is issuing directives and orders that conflict with our sworn duty as law officers to enforce the law and follow what Congress directed. Some of this simply came down to the fact that they are required to deport certain people if they're apprehended doing certain things. And they just issue guidelines and say don't deport people. And this is, think about it. So Secretary Napolitano and John Morton, her sub-supervisor, who's now just resigned, they were directing these agents to do things that undermine their ability to do the most basic part of law. And they filed a lawsuit in federal court. The judge has heard the lawsuit and heard the complaints. The Department of Justice sought to dismiss the complaint initially, and it's not been dismissed. The judge has let it proceed. And he, in effect, as I read the news article about it, basically said the Secretary is not above the law. I thought we learned that from Richard Nixon. The President is not above the law. Nobody's above the law in America. So this lawsuit is still ongoing. It's one of the most amazing things I've seen in how little it's been commented on and how significant that is. So we have the Immigration Customs, we have the Citizenship and Immigration Service officers. Like the ICE officers, they've written Congress and told us that they cannot do what the law requires them to do in this bill. They can't do what the law is requiring them to do now. They're overwhelmed by the requirements that's been placed upon them. And they said the law that's being considered today, S-744, that law makes the situation worse. Both of those agencies have written to the Congress and said it would weaken our national security and place our safety at risk in America. It wouldn't make things better and make it worse. So I think we need to say, how did we get here? And I believe we got here fundamentally because well-meaning senators decided that if you were going to pass a bill, you had to have La Raza happy. You had to have the unions happy. You had to have the business group happy. You had to have the chicken processors happy. And they all met with them. And they met with their pollsters and their political consultants and the politicians. And Chris Crane, the head of the ICE Officers Association, wrote them repeatedly, let me come tell you what it's really like out there. They refused to hear from him. They refused to hear from him and his ideas. He tried every way he could. I wrote him and asked if they meet with him, and they wouldn't do that. And so the legislation was written by people not connected to how the immigration system actually operates. The people trying their best every day to make this system lawful, make it effective, and make it something we can be proud of. And even under the legislation, it does not require of people who want to be citizens and want to be given legal status in America, it does not even require them to have a face-to-face meeting with a single person. And in fact, the DREAM Act, the DACA cases that are out there, they're not meeting with them face-to-face. They just give papers and read those papers and process them in a way that they have no capability of ascertaining whether those claims of legality are legitimate. And it is very clear from experts in the 9/11 Commission that face-to-face interviews make a huge difference. One of the hijackers that was supposed to be the terrorist, who was supposed to be on the plane that may have hit the Capitol of the United States or the White House, that fell in Pennsylvania. One of those was identified in a face-to-face meeting by an alert officer. And he held him up. He was not on that plane. And who knows, one more terrorist on that plane might have enabled them to control that plane and succeed in wreaking devastation on Washington, D.C. And maybe those patriots who brought that plane down, giving their lives to save this Capitol, may not have been able to do so had there been one more terrorist on that plane. So I just would got to say that this is really important material. And I don't know what the language is about the border and how many agents they've got there. But I know this, Senator Lee, we've had expert testimony from witnesses and from the 9/11 Commission that you need an entry-exit visa system. And we already have most of it. We've got, when you come in the country, they take your fingerprints, and you're clocked into the country. We're just not clocking people out of the country. So the 9/11 Commission and the follow-up meeting of that commission to review how America had complied with their original suggestions, repeated their concern that you need this entry-exit visa system. The current law that's been passed about 6 times, and it's current law today, and that law says we should have a biometric entry-exit visa system at all air, land, and seaports. This legislation guts that requirement. It eliminates a biometric, which means you don't use something like a fingerprint, which would be the most common thing to use. It would be some sort of electronic system that is recognized to be weaker, and it doesn't require it to be emplaced at the land ports. And the 9/11 Commission explicitly reviewed that, and they said the system won't work because people can fly into Houston, they can fly into Los Angeles, go back across the border, they can fly into New York and exit through Mexico. They can do these things, and you can't, therefore the system won't work. You don't know who overstayed and who didn't overstay. And what we learned was that it's not too expensive. They claimed it was going to be $25 billion. Where this figure came from? It was raised in committee. You may remember Senator Schumer said it would be $25 billion. Well, what we found was they did a pilot project in Atlanta and I believe Philadelphia, and people came through to get on a plane to depart America. They put their fingerprints on a machine. They go right on by, and those who are in violation, those who have warrants out for their arrest on a terrorist watch list are picked up. And amazingly, in Atlanta, they did 20,000 people as a pilot project, and they found 134, I believe, who had warrants for their arrest and got hits on the watch list. And some of these could be serious offenders. So I think that's just one more example of weaknesses in the legislation that apparently are not being addressed. One more proof that the bill before us today weakens current law, directly weakening our entry-exit visa system that the 9/11 Commission has said we must complete. And so there are a lot of things that I'm concerned about in the legislation. This is one of them. It's got to be fixed. I'm afraid we're not on the path to do that. Special interests have opposed that over the years. It's been debated and debated and debated, but finally a decision has been made. Multiple times Congress has directed this to occur, but it still has not occurred. So I wanted to share that. Maybe you have other thoughts that you'd like to share with our colleagues.
You mentioned a few moments ago that in some circumstances there's been some indication that perhaps the Secretary of Homeland Security believes that she's above the law. In some respects, when you read through this bill, you can conclude that if it passes, she will become the law. She will be the law. Because with hundreds and hundreds of instances in which she'll be given vast discretion to make all kinds of determinations about who stays, who doesn't, what happens under what circumstance, in what program, she actually sort of becomes the law. This becomes an act of administrative discretion rather than an act that helps bolster the rule of law. So that certainly is a concern that we've had over time. You know, we do wonder at times also why it is that we have legislation that remains secret for so long. You know, we've commented on the fact that we've been waiting for this mysterious amendment, and we've wondered why we haven't seen it. I wonder if the reason we haven't seen it is because they're still negotiating in secret, trying to sweeten the pot so that they can ram it through. Makes me wonder whether we can anticipate another Cornhusker kickback, another Louisiana purchase, yet another parallel between the Affordable Care Act and this legislation that we have before us today. It's another concern that I have. I'm also concerned by the same talking points to which I alluded earlier, the same talking points that we've had since before we even had this bill. The talking points that I alluded to earlier that I described as being to the effect of saying, you know, is there anything wrong with this bill? No. Is this bill excellent? Yes, absolutely it is. Those are the same talking points that convinced a lot of people to come out and support the bill before the bill even existed.
Senator Lee, you remember in committee, our able colleague, Senator Schumer, said this was the toughest bill ever, as I recall, and that it was tough as nails. But it looks like now we're told that it wasn't so tough because we've added an amendment that's going to make it tough. So that kind of what you're saying about the talking points, you have to go beyond the bill. If it was so tough to begin with, why do they need to pass another amendment now that makes it a lot tougher, they say?
I guess it wasn't tough enough, and they're trying to make it even tougher.